If a forensic expert witness testifies that the defendant matches evidence found at the crime scene, but the witness does not explain that they performed the final analysis, does that violate the Confrontation Clause of the Sixth Amendment? To find out, you have to read People versus Jordan, but it's 9 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Jordan. The citation for this case is 2023 New York Slip Opinion 05957, published by the Court of Appeals on November 20th of 2023. The issue in this case is whether testimony and evidence from the non-examining DNA analyst constitutes a violation of the Confrontation Clause of the Sixth Amendment. I'm going to explain all that in a few moments. The background I think is helpful to understand this case in its context is first what the Sixth Amendment is. The Sixth Amendment to the United States Constitution, it's part of the Bill of Rights, has a lot of provisions, protections for the accused in all criminal prosecutions, basically for defendants. One of them, an important one, is the Confrontation Clause, which says, in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. And what case law has developed about that right, it basically means that, there are out-of-court statements, okay, and a witness that makes a statement out of court that's testimonial in nature cannot be introduced against the defendant at trial unless the person who made the statement is unavailable and has previously been subject to cross-examination. That's the rule. And so it's an important question of what is testimonial? What is evidence that is testimonial, meaning the out-of-court statement that's used against the defendant at trial, with the expectation that it would be used at trial. Cases have held that not everything that happens with respect to a DNA profile development is testimonial. A lot of it is ministerial. That's the other catchword in this, ministerial work. So there's several parts of developing a DNA profile. There's using a lot of machinery. There's identification, amplification, creation of what's called a electropherogram. The relevant witness with respect to a DNA examination is the one who is directly involved in the critical final stage of the testing. The cases have held that when an analyst must exercise judgment using actual training, education, experience, and judgment to cull the data and generate a DNA profile, that person's out-of-court statement is testimonial. That's the part that you can't just call somebody else in to read. That would be a violation of the Confrontation Clause. The expert that reads the electropherogram and translates the peaks and valleys of this chart, of the DNA chart, that is the testimonial information that we need at trial that the defendant has to be able to confront without a violation of the Sixth Amendment. What are the facts here? The facts are that there's a store in Queens, New York that's robbed, and the robber leaves behind, when they flee, one of the robbers leaves behind a cell phone. The police swab that cell phone for DNA. They send it to the OCME, which is the Office of the Chief Medical Examiner, who process it and come up with a DNA profile. They submit it to CODIS, which is the combined DNA index system. It's their electronic data bank of DNA profiles, and it is a match to the defendant. They arrest the defendant, charge her with second-degree robbery and petty larceny. The OCME then, once they match the defendant, and now they arrest the defendant, then they seek a confirmatory buccal swab, which is basically you have an application to the judge to say, I want to swab the inside of the defendant's cheek to confirm that the defendant's DNA matches the DNA that we have on the crime scene swab, which they do, and it matches. So at trial now, the prosecution calls an analyst from the OCME to testify that the defendant's DNA matches the profile developed from the crime scene. And they also offer 3 exhibits into evidence, which are the files of the examinations. But here's the important part. The witness testified as to the procedures used at the laboratory of the OCME generally, but did not explain who performed the specific tasks for these profiles that were developed. The profile of the crime scene, the profile of the buccal swab. Those are the important ones. The original one that matched in CODIS, that never gets mentioned at trial because it would be prejudicial to the defendant to show that this defendant had a previous contact with the system. So the 2 important ones are the buccal swab, the confirmatory one, and the crime scene DNA. The witness also testified that he was a technical reviewer and reviewed the data and reports, but also acknowledged that somebody else ran the raw data and did the work and provided it to him. So that's a testimony from the witness. The defense objects and says violation of the Confrontation Clause. This is not the actual examining analyst. I'm entitled by the Sixth Amendment to confront the witness against me. It's not this person. It's the person who gave this person the information. The people, they say he is the analyst. The court allows the witness to testify. The defendant's ultimately convicted after the witness says the mixture of DNA is 25. This is how powerful his evidence is. The witness for the prosecution says, the analyst says, the mixture of DNA is 25.7 quadrillion times more probable to have originated from this defendant and another person than from two unknown people. The defendant's convicted of both counts. He appeals. The appellate division affirms the conviction, and it now goes to the Court of Appeals. And here what we have is a reversal. And the reversal is basically they say that testimony from an analyst is sufficient if they engage in the final level of DNA analysis, review the preliminary evidence processed by colleagues, produced the DNA profile, and expressed her expert opinion as to the DNA match. They actually give three ways that a person can testify and it not be a violation. Number one, they participated in the actual analysis. Number two, they directly supervised the final step that generated the DNA profile. Or number three, they conducted an independent analysis of the data used. In each of these scenarios, they are using their own human judgment to come up with the result. But here the testimony was insufficient to show that the work done by this testifying witness exercised that judgment and had the opportunity to identify errors if there were any, did not establish that he used the independent analysis of the raw data, and therefore it's a violation of the Confrontation Clause. It's not harmless error, convictions vacated, new trial ordered. That's the case of People versus Jordan. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.